The scene outside of the courthouse was tense.
Carmelo! Free Carmelo! I was free Carmelo!
When is a white boy been before an all-black jury? Tell us, media.
A story, a case, a trial that divided the community. Carmelo Anthony claiming self-defense after he stabbed and killed Austin Metcalf. The jury rejected Carmelo's story, convicted him of murder, and sentenced him to 35 years in prison.
Y'all know y'all wrong! Come on. I swear to God, I'm sick of this.
Now the aftermath of a trial the judge did not allow the nation to see. Austin's father setting the internet on fire after live streaming his raw emotions. And a public debate about what the surveillance video the judge kept from the public actually shows. And of course, the appeal. Will Carmelo Anthony get a second chance? So many reactions, so many unresolved issues after this dramatic verdict in Texas. No cameras inside the courtroom for the trial, now creating chaos after the trial. People are actually debating what the surveillance video showed, what the evidence means, what the witnesses testified to. Meanwhile, Austin Metcalf's father, raw and emotional, live streaming on the internet. What will happen next?
A judge bans cameras from his own courtroom. He says it is to protect the integrity of the trial. He says cameras change behavior. He says transparency is the wrong answer. Then the verdict comes in. 35 years. A 17-year-old boy. A community on fire. And the judge, the same judge who locked the public out, sits down in front of a camera and gives a television interview about the case. That happened. And a room full of legal experts watched it, and one of them said out loud, "Objection. Judge arguing facts not in evidence." This is the Carmelo Anthony case, not the basketball player, a teenager from Texas, a stabbing at a track meet, a murder conviction, and a courtroom so sealed from public view that right now, weeks after the verdict, people are still arguing about what the surveillance video actually shows.
Okay, so let's bring in Court TV anchor Cody Thomas, who was there in Texas, was there inside the courtroom, and actually saw this video, because this is the problem, right? We had no cameras in the courtroom. The evidence hasn't been released. So the public is going by what people are saying. And there are a lot of people out there with an agenda on both sides who can describe what they believe they saw. Cody, you have no agenda other than telling us what you saw and what you observed. So why don't you describe for us what you saw when the video was played and what was testified to about that video? Because this is an important piece of evidence. And, you know, you've got people saying that it's very clear in the video what happened here.
Because no one was allowed to watch the trial. My name is Vinnie Politan. You are about to understand exactly what went wrong here, why the conviction may not survive appeal, and what this case reveals about a principle that is older than any judge sitting on any bench in this country. The judicial branch belongs to the people.
The judicial branch is part of our government. It doesn't belong to any judge. It doesn't belong to any lawyer. It belongs to the people. Speaking of people, something else that happened in this case. The judge issued a gag order, which, you know, there's a First Amendment right to speech, and the gag order is something that should be narrowly addressed. And Austin's father, his son was stabbed to death, and he hasn't been able to talk about this. Well, he finally did in a live stream that everyone is talking about. A whole roller coaster of emotion and issues that he is.
Let us go back to the beginning. In April of 2025, at a track meet in Collin County, Texas, a 17-year-old named Carmelo Anthony stabbed and killed a boy named Austin Metcalf. The incident happened under a yellow memorial tent set up on the infield. Carmelo claimed self-defense. He said he was surrounded, confronted, and left with no choice. Prosecutors said the evidence told a different story. A jury of 12 people heard both sides and convicted Carmelo of murder in the first degree. He was sentenced to 35 years in prison. The community divided immediately, hard, along racial lines that people tried to deny and then could not. Carmelo is black. Austin was white. The jury that convicted him was all white. And the judge, Judge Roach of Collin County, had banned cameras and microphones from inside the courtroom before a single witness took the stand. That decision is the fault line underneath everything that followed.
The aftermath of the verdict and the trial in the Carmelo Anthony, Austin Metcalf case has not calmed down at all. As a matter of fact, it may have turned up a little bit in terms of the intensity of the public debate that is happening now. And it's all because this judge made a mistake. A mistake when he banned cameras and microphones from inside the courtroom. When you have a case that the public is invested in, the public is debating, and has caused conflict within your community, the remedy is transparency. Let the public see and hear all the evidence so they may understand. They may not agree with, but they may understand how the jury reached their verdict. But this judge did not do that, and we have chaos now. There is actual dispute about what the surveillance video shows. It's a piece of evidence that is part of a public record that everyone should have seen by now. They should have seen it during the course of the trial. That should have been televised. And all of a sudden, then maybe some of the debate would go away because you have people saying that it shows one thing and the other side is saying it shows something else, and maybe it shows absolutely nothing. But the public doesn't know because the public didn't see it. All because of the judge's mistake. We're still debating the evidence here. We're still debating what witnesses actually said. Because no one is getting anything firsthand. You're getting it secondhand. And many of the people delivering the messages have an agenda. So everything gets shaded and twisted. That's why Court TV puts cameras and microphones in there, so the public can see and hear the evidence and make their own minds up. The judicial branch is part of our government. It doesn't belong to any judge. It doesn't belong to any lawyer.
Here is something you need to understand about how the American court system works. In federal court, cameras are generally not permitted. But in state courts, each state makes its own rules. In Texas, it is what lawyers call judicial discretion, meaning it is entirely up to the judge. Judge Roach looked at this case, looked at the community tension surrounding it, looked at the cameras and microphones waiting outside, and said no. He believed, apparently, that keeping the proceedings private was the best way to ensure a fair trial. And here is where reasonable people can have a genuine disagreement, except that what happened next made it very hard to stay reasonable. Because after the verdict came in, after 35 years landed on a teenager, after a grieving father finally broke his court-ordered silence and went live on the internet with raw, unfiltered rage, after the community erupted with accusations and counter-accusations about what the evidence showed, after all of that chaos, the judge sat down for a television interview with WFAA and explained himself.
So I was a little surprised when I found out that the judge from the Carmelo Anthony case granted a TV interview. He did an interview with WFAA, spoke about a lot of things, but there was one thing that really caught my attention. Again, this is a TV interview. We have the audio. Let's take a listen.
I have seen from other cases around the country where cameras in the courtroom changed the way that the judge acted, the lawyers acted, some of the witnesses acted, and we were not going to have that here. We were going to really isolate the purpose for which we were here for, which is to have that fair trial, and cameras in the courtroom did not enter into that equation at all.
Objection. Judge arguing facts not in evidence.
His words were measured, professional. He said he had seen other high-profile cases where cameras in the courtroom changed how judges acted, how lawyers acted, how witnesses acted. He said he wanted to isolate the purpose of the proceeding, a fair trial. He said cameras did not enter into that equation. Vinnie Palatan's response was immediate. Objection. Judge arguing facts not in evidence.
You know, if you're a judge and a camera's in your courtroom and it changes the way you judge, that's your problem. That's not the problem with transparency. That's a problem with the judge. If a lawyer does anything other than try their case because a camera's in there, that's their problem. That's their mistake. That's their inability to be professional. But I'm surprised on a couple. All right, the judge didn't want cameras in the courtroom. I get it. We're going to talk about that, and I always talk about that. But he gave an interview about a case that just ended.
Think about what he is actually saying. He is saying that he, as a sitting judge, could not guarantee that he would behave the same way with a camera present as without one. He is saying that the lawyers in his courtroom might perform differently for an audience. He is saying that the solution to those problems is to remove the camera, rather than to simply be a professional. And he is saying all of this in a television interview about a case that is currently open to appeal. Brian Weiss, one of the most respected criminal appellate attorneys in the state of Texas, a man who has argued and won cases at the federal circuit level, put it precisely.
People have been married, certainly most of the people that you and I know have been on the air with. A couple of quick takes. Number one, I know Judge Roach. I met Judge Roach when I was a special prosecutor in the Ken Paxton case, investigating and prosecuting the Attorney General, now Republican nominee for junior senator, because that all happened initially out of the Collin County Courthouse where this trial was. And I heard nothing but good things about Judge Roach. I maybe even met him at a seminar. But number one, when I talk to judges and lawyers and prosecutors at seminars about dealing with the media, it's one thing for a prosecutor or a defense attorney to go on the air. I don't think there should ever be a case where a judge, the guy that calls balls and strikes and wears the dress and everything, should go on the air unless it's in some educational capacity. And I know what this judge's clip was not particularly incendiary. That's the other take. I could not disagree with him more. And again, I think, Vinny, you and I, are cut from the same cloth because we're old Court TV alums back in 93 and 94. And you make a great point, not just to suck up. If you as a judge, if you as a jurist are in any way, shape, or form impacted or affected by the fact that there's a camera, which is so unobtrusive that I found people forget about it in the first 90 seconds, then you should not be behind home plate in Game 7 of the World Series. You ought to be working at Chick-fil-A. The other thing is that if you are going to let witnesses or advocates play to the camera, and again, the three most cliched things in America, French cuisine, Notre Dame football, and lawyers playing to the camera, nonsensical at best.
It is. You're not playing to the camera. You're playing to the jury. Like, the lawyers are playing to the jury. The jury makes the decision. The jury decides whether they win or lose. That's who they play to. I mean, I've covered, this isn't the first high-profile case that we've covered through the years. There was another one that had sort of the racial tension that this one had, involving a victim named George Floyd. And the judge in that case, Judge Cahill, the state of Minnesota had never had a camera in a courtroom, but Judge Cahill was smart enough knowing that case for that community and for the nation was important for the nation to see the evidence and hear it so they could understand the verdict and understand the way the evidence went in. And whatever you believed about the evidence in the case, the bottom line was prosecutors won that case. Their expert was amazing. The defense expert was meh. And that made a huge difference in the case. And that's what the transparency showed. And if you don't agree with it, you have a basis to not agree with it because you get to see and hear everything. Will this be a problem?
If you as a judge,
if you as a jurist are in any way, shape, or form impacted or affected by the fact that there's a camera, which is so unobtrusive that I found people forget about it in the first 90 seconds, then you should not be behind home plate in Game 7 of the World Series. You ought to be working at Chick-fil-A. The other thing is that if you are going to let witnesses or advocates play to the camera. And again, you know, the three most cliched things in America: French cuisine, Notre Dame football, and lawyers playing to the camera. Nonsensical at best.
It is. You're not.
Are affected by the presence of a camera, you should not be behind home plate in Game 7 of the World Series. You ought to be working at Chick-fil-A. That is a colorful way of saying something serious. Courtrooms are not private property. They are not the domain of the judge or the lawyers or even the defendant. They are public institutions, funded by public taxes and operating under public authority. When a case divides a community, as this one unmistakably did, transparency is not a threat to justice. It is the only path toward it.
Absolutely. Absolutely. If the public had transparency and heard just the sheer preparedness from the prosecution, every time the defense tried to get the ball rolling, the prosecutor had something ready to go. And in the way he presented his case, Vinny, I mean, I know you're a former prosecutor. You understand how these strategies work. It was very simplistic and digestible for the jury. For example, the defense called this one witness who was a student who knew Carmelo, went to school with Carmelo, and talked about, you know, there was an argument about the tent culture, how tents were like locker rooms and you shouldn't be under them and this and that. This student was saying, no, track meets were very social. I'd be under the tent for 15 minutes with some of my friends if I saw them. I've actually been under the memorial tent with Carmelo. So he's going through all of this different stuff. And then the prosecutor gets up on cross-examination, like, oh, so, you know, they're very social. Yes, sir. If someone asked you or asked you to leave their tent, would you have stuck around? No, sir, I wouldn't. I probably would not have done that. So, I mean, there's the answer right there, right? You know, just simplistic questioning. Are you surprised that a knife was at a track meet? Yes, sir. Knives don't really come to track meets. No, sir. Were you surprised that, you know, your teammate was you know, the suspect here? Yes, sir. You know, just all of those sorts of simplistic, no matter how the defense tried to paint something. And, you know, there were some moments where I was like, okay, here, the ball's rolling now. And as soon as the prosecutor gets up there, it's just like, you know, it's almost like he was trying to play more of the common sense, you know, sort of play here. But I think if cameras were in there, public transparency always, as you said here at Court TV, is always important when it comes to these trials, so the community can understand and, you know, not be so polarized. I mean, of course, there's going to be opinions and judgments on both sides, but I think it would have helped them see why this conviction came and he was ultimately sentenced to these 35 years.
Yeah. And but I mean, for the public trust in our system of government, which works for the people, like, you don't necessarily have to agree with the verdict, but maybe at least you would understand and say, oh yeah, like whether you believe the defense attorneys didn't do a good job or witnesses went south or whatever happened, you may understand how the jury came to their conclusion. But where we are now, it's like the reaction to this, it's as polarizing as ever. Cody Thomas, Court TV anchor, working hard. Appreciate your time always, sir. Thank you so much.
And now, because that path was closed, here is what we are left with. There is a piece of surveillance video at the center of this case. It was recorded from a camera mounted on a tall light pole on the far side of the stadium. When zoomed out, it is grainy but watchable. When zoomed in, which it had to be in order to show what happened under that yellow tent, it looked, according to Cody Thomas of Court TV, who was inside the courtroom and watched it played, like footage from a 7-Eleven security camera.
Yeah, well, I mean, this is the most important piece of evidence. It's kind of the crux of the whole case here. But the thing about this video, Vinny, and the prosecutors admitted this before it was presented while that forensic video analyst was on the stand, is that the video is not the best quality. It's, first of all, it's one of those, you know how a football stadium is set up and you have the big tall light posts that light the whole stadium. It seems like it's a camera on one of those light posts on the opposite side from where everything's going down. So when it's zoomed out, it looks pretty good quality. But when you have to zoom all the way in like this on a little blip, you know you're going to lose a lot of pixelation there. It's going to be really grainy. So they zoomed in, and, you know, now it looks like video, you see it like a 7-Eleven. It's real grainy. You can kind of make out what's going on. You can see the yellow memorial tent. But again, they admitted there's no real distinguishables here. You're not seeing facial features. You're not seeing the logos of brands on clothing. So it's just a low quality video. But you see at one point in time, you see in the bleachers, you see the yellow tent. It's kind of at the center mass of the video. And then they zoom out just a tad so you can see Carmelo come up out of what's like the tunnel of the bleachers. You know, when you come up and you go sit around, he's coming up from under there. You see him come there and he stands there for a few seconds, and then he's walking towards this direction. So the tent's right here. He's walking towards the tent here. He's there at the tent for around 2 minutes. Then eventually you see Austin Metcalf and his 3 or 4 friends who are walking from the middle school where they were visiting their coach for a little bit that morning. They're walking from the opposite direction. So Carmelo's here for 2 minutes. They get there, and then the whole ordeal goes down in like 4.5 to 5 minutes. But under the tent, you got to remember there's a whole team under this tent. You can't see rainfall. All you see is there's people under a tent. They look like these humanoid blobs. You can tell they're human beings, but it's just a bunch of masses, right? You're not looking at who's sitting down, who's standing up, especially if they're intermixed in there. You know, maybe if they're at the front, you can see if they're sitting on the bleachers, but all in the crowd, you can't really see much of anything. And then what the media analyst highlights at one point in time, you see kind of one of these darker figures. There's like a jolt. And so they're saying that was kind of like the push. And then right after that little jolt, you see everyone disperse. And then, of course, they spot shadow. This was Carmelo because the other, I'm sure Memorial's team was in some dark gear because Carmelo had on a gray hoodie type situation. So he was in lighter clothing. Then you see him run off and they spot shadow him. And then you just see a bunch of disbursement. There was no, you don't see 2 hands, 1 hand sitting down, 2 people towering over. There's not really any real identifiables other than there's a memorial tent. Here's a bunch of people under there. This is what they say was a little jolt, which was the push, and then a bunch of disbursement. That's all you really see.
Blurry. Pixelated. The tent is visible. Human figures move underneath it. At one point, there was what analysts described as a brief jolt, a push, and then everyone disperses. Carmelo, wearing a gray hoodie, runs up 3 or 4 rows of bleachers. That is where the knife was found. Then he runs toward the track. That is essentially all that is visible. The prosecution's own forensic video analyst acknowledged before the video was presented that the quality was poor. No facial features, no clothing logos, no way to identify individuals with certainty once the action moved under the tent. The only things that could be established from the footage were that Carmelo walked to the tent, that Austin Madoff and his friends arrived from the opposite direction, that something happened, and that Carmelo ran. Here is the question that the public is now furiously debating. Was Carmelo surrounded by a group? Was he the aggressor? Was this a one-on-one confrontation or something more chaotic? The video cannot answer that question. And here is the thing that should make every person watching this pay very close attention. The witnesses who testified, including defense witnesses, described a confrontation between 2 boys, not a group surrounding Carmelo, not multiple people physically threatening him simultaneously. The testimony from under that tent was, according to Cody Thomas, consistent across multiple witnesses.
So sometimes, and I've seen this in trials, you go through a video and you may play it for different witnesses who were there. Mm-hmm. And then they, having been there, looking at the video, can kind of describe to you what's happening. Mm-hmm. Did any of that take place to try to clarify exactly what is going on and whether or not Carmelo Anthony is surrounded, whether or not a physical confrontation it's you can really tell how forceful the physical confrontation initially is? I mean,
in a very minor capacity, Vinny. I mean, because you got to remember, all of these students that testified under the state said there was no sort of surrounding that was happening. It was described as, this kind of one-on-one thing. And, actually in the closing arguments, the prosecutor was saying, they're trying to say the 2 brothers or all these multiple people were jumping on him. But on the body cam with the video, once he was apprehended, he was saying, I told him not to put his hands on me, not I told they not to put their hands on me. So that was a big deal in the closing arguments. But there was one student that got up there who was actually on the field warming up. And so you saw an angle of, a couple of kids on the field, and you saw the angle of where the tent was. And what they were trying to do there is kind of talk about how this student's timeline of when he walked over and saw the commotion just didn't add up, and trying to kind of discredit his credibility a little bit. But no students were sitting there saying, yeah, that was me. You see me walking there, and then you see this push, and you see this person to the left, and they're moving up the bleachers. There was none of that real specificity, other than that one student on the field, just to show that his times weren't lining up when he said he walked over there, because they showed that he didn't walk at all when the moment of the stabbing.
Two boys. Carmelo sitting, Austin standing. Words exchanged. Then, a knife. The defense had 6 witnesses. One of those witnesses, a defense witness, admitted he believed Carmelo was the aggressor. The defense never showed the video to the jury during their own case.
They didn't do that at all. And, there's been a lot of criticism regarding the defense of Carmelo Anthony here with, 6 witnesses, a couple of student witnesses, one of those student witnesses that actually admitted that he believed Carmelo was the aggressor, a defense witness saying that. But the defense didn't use the video in any capacity, which, they didn't do that. They didn't explain even why he had a knife in the first place, which I thought that was something they would try to harp on a little bit, just saying, he had it because he liked to go camping. He had it because, you had to cut nylon if you're setting up the tent. They didn't even touch on why the knife was even there in the first place. It seemed like a lot of missed opportunities and holes in the defense's case, and especially after they ended somewhat abruptly. But to your point, Vinny, the video was not shown during the defense's case in any capacity.
And did they have any witness, either through their cross-examination or the direct examination of their own witnesses, who described Carmelo Anthony being surrounded or being confronted by a group?
Nothing group, nothing like that. There were multiple people. They all kind of described the same situation. They got into there. A lot of people were asking him to move. This is defense's witnesses now. Just want to reiterate, asking him to leave. They saw commotion. They're looking around. They weren't scared. They just thought it was 2 boys, kind of going at it, saying whatever else to each other. But it was all
2 boys, not a situation of, I'm not going to say a gang, but a group of individuals, whether it's 2, 3, 4, sort of surrounding or physically confronting or intimidating all at the same time, all standing up and kind of getting around him. They never called a witness to point at the footage and say, this is where Carmelo was surrounded. They never explained in any meaningful detail why Carmelo had a knife at a track meet in the first place. Now stop. We are roughly halfway through what this case has to teach you, and I need you to understand something before we go further. Everything you have heard so far is what the jury saw. The prosecution was prepared, disciplined, and presented a simple and digestible case. The defense, by multiple accounts from people who were in that room, had significant gaps. And a 17-year-old boy is now going to prison for 35 years. But the story is not over, because the conviction that was just handed down is not the end of this case. It may, in fact, be closer to the beginning. A notice of appeal has been filed. That is... So, as you would expect, you're convicted of murder. You're sentenced to 35 years. You probably want to see if you can get a new trial, a second look, a second chance at all this. So, Brian Weiss, you're an appellate expert as well, and that's, anytime I have a question about Texas law, you're on speed dial. I don't know if I still have speed dial, but if I still had speed dial, you'd be on it.
I'd be on it again.
Let me start with the first issue that I was shocked by, and again, I didn't get to actually see the testimony because the judge did not allow us to see it. But the reporting is that each eyewitness kind of finished their testimony by saying this was not self-defense. Is that okay? Because I thought that's what the trial was about, and I thought that was the question that the jury had to answer, whether or not it was self-defense. Can lay witnesses in their testimony tell the jury, in their own opinion, that it was not self-defense?
The short answer is they're not supposed to. And this is one of the ironies or oddities, if you will, about the criminal justice system. The only kind of criminal case where a layperson can give the ultimate opinion as to guilt or innocence is, of all things, a DWI case or DUI, as they say in some states, because everybody knows what intoxication is. Self-defense is a question of law that ultimately the jury decides based on the facts. Now, a witness can testify. You can't, I don't think you should be able to answer a shove with a stab like Bill Worski so ably argued. Or you could say that I believe that Carmelo Anthony had an opportunity to retreat, that is to leave the tent. But I was shocked that these lay witnesses, if you will, were permitted to testify as to the ultimate legal conclusion. That's an issue. But it's interesting because I thought the issue that I thought you were going to lead with is the Batson claim.
Oh, all right. Well, I know you want to go there. But let's just start here. Is that a big deal? The fact that the witnesses said this was not self-defense, 0 to 10, just give it a number, how big of a deal it is.
On its own, on the merits, it could be a 7. But if I could just kind of throw something in that I think your viewers would want to know about the appellate process, appellate courts don't sit to review questions of guilt or innocence. They review whether or not the trial was fundamentally fair based on legal rulings that the court made. And there's something called the harmless error rule. And that's because nobody's perfect. We recruit all the participants, the judge, the prosecutor, the defense lawyer, the witnesses, the cops, from the human race, which means there's going to be human error. And so there are going to be mistakes. And because the Constitution doesn't entitle you, not even in New Jersey, to a perfect trial, you're entitled to a fair one. So I believe that while that could be classified as a legal mistake, what we call error, E-R-R-O-R, an appellate court could find that based on the allegedly overwhelming evidence that it didn't impact the outcome of the proceeding. But again, that's a potential issue.
The first issue is this. Witness after witness after witness at trial concluded their testimony by stating, as a matter of opinion, that what Carmelo did was not self-defense. Think carefully about what that means. Self-defense in Texas is a legal question. It is not a fact that a witness observes and reports. It is a legal conclusion that the jury, and only the jury, is supposed to reach based on the evidence. Lay witnesses, meaning non-expert witnesses who are simply testifying about what they saw, are generally not permitted to give the ultimate legal conclusion in a case. The one exception in Texas law is DWI cases, because the concept of intoxication is something that ordinary people can reasonably assess. Self-defense is not. Self-defense involves a complex analysis of threat, proportionality, opportunity to retreat, and state of mind. The fact that multiple witnesses were apparently permitted to tell the jury this was not self-defense, not just to describe what they saw.
Yeah, I thought it was a big issue because, like, it wasn't just one witness. It was like witness after witness after witness. All right, let's get to what you thought my lead was going to be. And I was debating between the two. The fact that there were no black jurors. And you talked about Batson challenges. Let's talk about that. What's going on there? Is that a real issue in this case at the appellate level?
That is, as we say in journalism, that's the lead that you don't want to bury. And I know that enough of your viewers have probably binge watched Law and Order or seen you on the air talking about what Batson is. But Batson comes from, I believe, a 1984 Supreme Court case called Batson versus Kentucky, and that has been modified over the years, that essentially says that while a prosecutor can exercise as many challenges for cause as he or she can, that is based on a juror's inability to follow the law, that they can only exercise their peremptory challenges for reasons that are not related to race or for any racial reason or for any racial pretext. So what, in essence, this case presents, as I understand it, because again, I followed it, but I followed it on, this device right here, is that there were 3 black potential jurors, what we call veneer members in Texas, who were struck by the prosecutor peremptorily, meaning for no reason at all, is based on their 10 that both sides get in Texas in a felony. And once the defendant, in this case, Mr. Anthony's lawyers make what we call a prima facie case. Judge, on the record outside the jury's presence, now that the jury's seated, I want to note for the record there are no African-American jurors. And I want the court to note for the record that the prosecutor exercised X number of challenges on black jurors. At that point, the court will say, fine, the defendant has made a prima facie case. Mr. Worski, I want you to tell the court for the record why you struck those black jurors. And my understanding is that they were struck because I think they were not necessarily teachers, but educators who might have felt sympathy for a 17-year-old kid if they're around 17-year-old kids all the time. Now, once that happens, the prosecution has initially rebutted that claim that you used your challenges improperly. It's then incumbent upon the defense attorney, and this is where it's tricky, You have to show that potential jurors, veneer members, who were similarly situated to these 3 black educators who were struck or not struck, and they were white. So my understanding is that there were white veneer members who may have been teachers or educators who were not struck. If that's the only reason, I love that issue.
That's a home run, right? So you have black teachers, white teachers. Prosecutors get rid of the black teachers, but don't get rid of the white teachers. And then all of a sudden, their reasoning for getting rid of the potential black jurors kind of falls by the wayside because you didn't. Everything else is the same, except the fact of what color their skin is.
Right, and the word that we use, you use the legal expression "falling apart," which I like. It's called a pretext. That basically this is BS. And I have one back.
All right, 0 to 10. Give me a number because I have one more issue I want to get to.
8 or 9.
A peremptory challenge is a tool that allows either side to dismiss a potential juror without giving a reason. Each side gets 10 of them in a Texas felony case. The Supreme Court ruled in a 1986 case called Batson versus Kentucky that peremptory challenges cannot be used for racial reason. You cannot strike a juror because of their race. If the defense raises what is called a prima facie case, meaning they put on the record that the prosecution struck all the black jurors and ask for an explanation, the prosecution must provide a race-neutral reason for each strike. The prosecution's stated reason for striking the 3 black jurors in this case was, according to Brian Weiss's understanding, that they were educators who might be sympathetic to a 17-year-old defendant because of their professional experience with young people. That is a facially race-neutral reason. It sounds reasonable on its surface. But here is where it falls apart. If there were white jurors who were also teachers or educators, and there may have been, and those white jurors were not struck, then the stated reason is what lawyers call a pretext, a cover story. Because if the real reason to strike were sympathy toward youth based on working with teenagers, that logic would apply equally to white educators. The fact that it was applied only to black educators suggests that the real criterion was race, with the professional background offered as justification after the fact. Brian Weiss rates this issue an 8 or 9 out of 10.
All right, 0 to 10, give me a number because I have one more issue I want to get to.
8 or 9.
Let that land for a moment. An 8 or 9 out of 10 means that if the defense on appeal can demonstrate that white educators were seated on this jury while black educators were struck, there is a serious argument that the conviction must be thrown out and the case retried before a properly selected jury. The third issue is one that lawyers argue about in hushed tones, because it requires accusing the people who were supposed to protect the defendant of failing him. It is called ineffective assistance of counsel.
And we spent some time in this episode talking about the bad blood between the families. It would seem to be in Carmelo Anthony's family's best interest to mend those fences, right? To try to create, if they have a relationship with Jeff Metcalf and with Hunter, Austin's twin brother, if there is some sort of moment of coming together, that could be Carmelo's best opportunity to get parole sometime down the road if Jeff Metcalf speaks, and says, okay, he's been punished, and Hunter, and there's some sort of coming together, some level of healing there, rather than where there seem to be going now, which is in the opposite direction of that.
Okay, I'm going to go out on a limb here and say that Khloe Kardashian has a better shot of winning the Heisman Trophy than that happening. That's not going to happen.
Why? Why is that not going to happen?
Because there are so many things about this case, not the least of which is the hot button, third rail element of race, that I think that it's highly unlikely in the short term. And let me say this while I'm at it. I see that the mom and dad have done a series of interviews with some, market 290 whatever affiliate. You've got to turn down the volume on this right now, because all of this that's been going on outside the Collin County Courthouse, where I spent a bunch of time, That's not helpful. I know people are angry. I know people want to vent. But courts of appeals and trial judges don't want to think that their decisions are impacted in any way, shape, or form by public clamor or outcry. So dial it down. My advice.
It's time to do what Mackenzie Sharilla's parents should have done, which is just zip it.
So.
Brian Weiss,
Exactly.
Always great to catch up with you. I gotta make my way back to Texas. When I do, you're taking me out for barbecue.
Brian Weiss gave this approximately zero chance of happening. He is probably right. What remains is the legal record, the sealed courtroom, the surveillance video that no one outside a handful of people has ever actually seen, the witnesses whose testimony was never broadcast, the evidence that was weighed by 12 jurors whose deliberations produced a verdict the public is now debating with the passion and certainty of people who were never in the room. And a judge who decided the answer to all of that was silence, and then sat down in front of a camera to explain why. The judicial branch is part of our government. It was designed to operate in public, not for the convenience of judges, not for the comfort of lawyers, not even ultimately for the protection of defendants. It operates in public because justice that cannot be observed cannot be trusted. And trust, once lost in a community already divided, is extraordinarily difficult to rebuild, especially when the person who could have prevented the damage gave an interview explaining why he chose not to try. The next time someone tells you that cameras in courtrooms are a threat to fair proceedings...
Okay, there's a lot of emotion still in this case, and I get it. But at the end of the day, if Carmelo Anthony and his family want to have an opportunity for a second chance at life after committing murder, Brian's right. They got to turn down the temperature and try to heal the community, heal your family, and maybe reach out and help Austin Metcalf's family heal as well. That's all the time for this time. Until next time, I'm Vinny Politan. Thank you for watching, and please don't forget to hug the kids.
Ask them one question. If the proceeding is truly fair, what exactly are they afraid you will see?